Thank you to the organizers for providing me the opportunity to testify at this important tribunal. I will discuss the right to self-determination, terrorism versus national liberation movements, and international humanitarian law in the context of the struggle of the Filipino people against repression by the governments of the Philippines and the United States. Several treaties, including the UN Charter, International Covenant on Civil and Political Rights, or the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, enshrine the right of peoples to self-determination. This right is considered jus cogens, a peremptory norm and the highest form of international law, from which no derogation is permitted. In its advisory opinion on Israel's separation wall, the International Court of Justice ruled that the principle of self-determination of peoples has been enshrined in the UN Charter and reaffirmed by the General Assembly, pursuant to which every state has the duty to refrain from any forcible action which deprives peoples of their right to self-determination. The right to self-determination includes, but isn't limited to, the right of peoples to control their own land and natural resources, the right to be free from demographic manipulations by any third party, and the right to determine their own political status, economic development, and their own futures. Continuing the US policy of the so-called pivot to Asia as a counterweight to China, US President Barack Obama enlisted the Aquino government to negotiate the Enhanced Defense Cooperation Agreement. Although purporting to maintain Philippine sovereignty over US military bases on Mindanao Island and civilian airstrips on Luzon, it granted significant powers to the United States. The US seeks to return to its two former military bases in Subic and Clark, which it left in 1992. These bases were critical to the US imperial war in Vietnam. This violates the well-established right of the Filipino people to self-determination. Under international law, the Filipino people have a legal right to resist the repression of the Philippine government, including by the use of armed struggle. A 1982 resolution of the UN General Assembly reaffirmed the legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial and foreign domination and foreign occupation by all available means, including armed struggle. After September 11th, 2001, US President George W. Bush called the Philippines a second front of the war on terror. The Philippine government used this so-called war on terror as an excuse to escalate its generations-long war against Muslim separatists in the southern Philippines and other individuals and organizations who opposed the policies of the Philippine government. People and groups have been labeled terrorists by the Philippine government, the US government, and other countries at the behest of the United States. The Philippine government engages in red tagging or political targeting. Targets are frequently activists, organizers, people's lawyers, consultants, peace advocates, humanitarian aid workers, and journalists. But it is the Philippine government that is engaging in terrorism backed by the United States. M. Calliope K. Cufa, former UN Special Rapporteur on Human Rights and Terrorism, explained that regime or government terror is conducted by organs of the state against its own population for the purpose of preserving a regime or suppressing challenges to its authority. Regime or government terrorism is characterized by kidnapping and assassination of political opponents of the government by the police, secret service, army, or security forces, imprisonment without trial, persecution and torture, massacres of racial or religious minorities or certain social classes, internment in concentration camps, and government by fear. Regime or governmental state terrorism is legitimized by the law the state itself has established. Kufa distinguished between terrorism and wars of national liberation in the context of the right to self-determination, which are memorialized in the 1999 Convention of the Organization of Islamic Conference on Combating International Terrorism. That convention protects people's struggles, including armed struggle against foreign occupation, aggression, colonialism, and hegemony, aimed at liberation and self-determination in accordance with the principles of international law, which shall not be considered a terrorist crime. The 1998 Arab Convention on the Suppression of Terrorism likewise accepts struggles for self-determination from the definition of terrorist crime. The National Democratic Front of the Philippines, or NDFP, is waging a war of national liberation through its armed component, the New People's Army, in the exercise of the Filipino people's inherent right of self-determination. The Philippine government, fully supported and enabled by the US government, has engaged in violent repression of the Filipino people through counterinsurgency and counterterrorism campaigns, as well as widespread violations of international human rights and humanitarian law. The NDFP's armed struggle against the Philippine government is a war of national liberation for self-determination under Additional Protocol 1 to the Geneva Conventions, which says that armed conflicts in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination are protected by the Geneva Conventions. State-sponsored or state-supported terrorism includes overt or covert assistance or support by a state to terrorist agents in order to subvert or destabilize another state or its government, according to Kufa. State-sponsored terrorism occurs when a government plans, aids, directs, and controls terrorist operations in another country. This is sometimes called surrogate warfare. The United States is engaging in this form of terrorism in the Philippines. Much of the military equipment and training of the Philippine government comes from the US and is used to commit widespread international humanitarian law violations and international human rights violations. The US provides the Philippine government with more than $1.14 billion worth of equipment and training, making it the largest recipient of US aid in the Indo-Pacific region. International humanitarian law, or IHL, requires countries to make a distinction between combatants, armies, tanks, and other military equipment on the one hand, and civilians and civilian objects, such as schools, hospitals, and civilian residences on the other. Civilians and civilian objects are not to be targeted. Weapons that do not discriminate between civilians and combatants are generally prohibited, and notice of planned attacks must be given to civilian populations to allow them to leave the area before an attack. IHL also requires proportionality in the use of military strikes, allowing only that amount of force necessary to achieve the military objective. The Philippines' U.S.-inspired counterinsurgency program does not distinguish between civilians and combatants, which is considered a war crime under the Geneva Conventions. The counterinsurgency program has led to massive repression, including the war crimes of extrajudicial killings, collective punishment, forcible displacement of the civilian population, abductions and forced disappearances, torture and cruel treatment, the use of violence to spread terror, arbitrary detention, and the use of indiscriminate weapons. Unarmed drones are being used to surveil areas prior to armed attacks or indiscriminate bombardment of communities with helicopters and howitzers. This drone surveillance instills terror in the population who see and hear the buzzing of the drones above their homes. Civilians, including children, members of the New People's Army who have been rendered hors de combat, and civilian objects have been targeted. Bodies have been desecrated, which violates the Fourth Geneva Convention, as well as Additional Protocol 1 to Geneva. The Philippines is a party to both the Geneva Conventions and its Protocol 1. The regime has also impeded humanitarian aid and relief supplies intended for civilians and civilian communities. Hundreds of activists who belong to progressive organizations have been murdered by the Philippine military and paramilitary death squads. These actions violate Common Article 3 of the Geneva Conventions and constitute war crimes under the Rome Statute of the International Criminal Court, or the ICC, which forbid violence to life and person, in particular murder, cruel treatment and torture, and outrages upon personal dignity, particularly humiliating and degrading treatment. In 2019, the Philippines withdrew its ratification of the Rome Statute. The U.S. has unsigned and refused to ratify the Rome Statute. But Philippine and U.S. officials can be prosecuted for war crimes and aiding and abetting war crimes, respectively, by national courts under the well-established doctrine of universal jurisdiction. This doctrine allows countries to prosecute foreign nationals for the most heinous of crimes, even when there is no direct connection with the prosecuting country. The ICCPR forbids torture and other cruel, inhuman, or degrading treatment or punishment. It guarantees liberty and security of person and forbids arbitrary detention, a common practice of the Philippine military and paramilitary. Torture and cruel, inhuman, or degrading treatment is prohibited by the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT. The Philippine military and paramilitary forces attempt to rationalize their harsh treatment as necessary to maintain national security against organizations that seek to challenge and even overthrow the government. However, CAT says, quote, no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as a justification for torture, unquote. Both the Philippines and the United States are parties to the CAT. The Philippine government has a duty to prosecute or extradite those who commit or are complicit in the commission of torture under both CAT and the Geneva Conventions. In December 2005, the General Assembly passed a resolution called Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law, and serious violations of international humanitarian law. This resolution reaffirms the rights in the instruments mentioned above. Principle 7 explains that remedies for gross violations of international human rights law and serious violations of international humanitarian law include the victim's right to the following as provided for under international law. First, equal and effective access to justice. Second, adequate, effective, and prompt reparation for harm suffered. And third, access to relevant information concerning violations and reparations mechanisms. Yet victims in the Philippines have been denied remedies for their suffering. The Geneva Conventions list as a war crime the passing of sentences and carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all judicial guarantees, which are generally recognized as indispensable. The Philippine government and its paramilitary forces have carried out numerous extrajudicial killings. The protect life principle demands that lethal force may not be used intentionally merely to protect law and order or to serve other similar interests, such as to arrest a suspected criminal or to safeguard other interests, such as property. Former UN Special Rapporteur on Extrajudicial Summary or Arbitrary Executions, Christoph Haynes, wrote in his 2014 report to the UN Human Rights Council. The primary aim must be to save life. In practice, this means that only the protection of life can meet the proportionality requirement where lethal force is used intentionally, and the protection of life can be the only legitimate objective for the use of such force, according to Haynes. The Philippine government consistently violates this principle as well. In conclusion, the Philippine government routinely violates the Filipino people's right to self-determination. The National Liberation Movement in the Philippines does not constitute terrorism. The Filipino people have the right to resist repression by the regime by all available means, including armed struggle. The Philippine government consistently violates international human rights law and international humanitarian law. Officials of the Philippine government and the U.S. government who enable the commission of these crimes should be held accountable in national courts under the principle of universal jurisdiction. I want to emphasize that people's tribunals, while essentially political in nature, can serve as alternative fora and provide a people's record for future litigation, both nationally and internationally, as well as organizing efforts. For example, after the 2009 People's Tribunal of Conscience in support of the Vietnamese victims of Agent Orange, in which I served as a juror, a French-Vietnamese woman filed a lawsuit in 2014 against the chemical companies who manufactured and sold dioxin used in Agent Orange that the U.S. military sprayed on Vietnam during the American war there. As someone who testifies as a legal expert, I support people's tribunals, such as the one proceeding right now in Brussels. And I look forward to the verdict and decision that could be useful to help remedy the violations of international humanitarian law, hold the perpetrators accountable, and provide justice and ultimately respect for the rights of the victims in particular and the struggling Filipino people as a whole. Thank you very much.